A pleasant day once more to all the subscribers and those who are going to subscribe. Again, thank you so much for patronizing my channel. Hope that I could be able to help more and more aspirants and even those who are not taking the board exam. Since the topic that we're discussing is about the law, it can give knowledge to everyone as regards to their rights and other things. Okay, now our topic is now the part 4 of the book 1. This focuses on the classes of crime according to gravity. Okay, but yours truly made a special presentation. Okay, I put into one slides or one presentation 9 or 10 articles, okay, of the revised penal code, which covers also the principles of penalty, okay, and others. Okay, so let's begin now. Once more, this is Dr. Ariel D. Manlusok, Director of the ADMRC. Okay, so here we are. We have here 3 articles, okay? The article 9, which discuss the classes of felony, which pertains to the grave felony, less grave felonies, and light felonies. Okay, then as you can see, we have article 25 here and article 26. Now the reason why I put them beside, because these are the basis in classifying felonies according to gravity. Okay, so as we said, there are 3 classes of felony according to gravity: the grave, the less grave, and the light felony. And how are we going to classify or define them? Once the crime is punished with the penalty of either capital punishment or afflictive penalty, that crime is classified as grave felony. Okay? So if the crime is punished by death penalty, reclusion perpetua, reclusion temporal, or prison mayor. So those underlined are the so-called principal penalty. That crime or those crimes that carries this penalty are classified as grave felonies. Now, when it comes to fine, if the amount of fine imposable to a penalty to a crime is exceeding or more than 6,000, then that is also considered as a grave felonies. Although, just last year, if I'm not mistaken, the President signed into law Republic Act 10951, okay, which increases the amount of fine, because as you know, the amount of fine under the revise is decades ago. That was 1932 when the revise was approved. So, pursuant to Republic Act 10951, once the fine is already more than 2 million, that is classified as a grave felony. Okay? So, yan po how we define grave felony. What about less grave felony? Once the crime or felony is punished by correctional penalty. And what are correctional penalty? Prison correctional, arresto mayor, suspension, and distierro. That is classified as what? Less grave felony. With regard to the fine, under the old law, not less than 200, but not more than 6,000. But again, as amended by RA 10951, once the fine now is 40,000 to 2 million, that is already a less grave felony. Okay? Now, the last one is the light felony. Once the light or the crime or offense or felony is punished by light penalty, which is arresto menor, okay, or is public censure for that purpose, is also classified as light felonies naman. And on the other hand, with regard to fine, if the fine is not more than 200 in the old law, but under the new law, not more than 40K or 40,000, that is considered as what? Light felonies. Okay? Now, take note, penalties can also be classified in 2 ways. No? We have principal penalty and accessory penalties. Okay? As provided by the Revised Penal Code, Book 1. The capital punishment, reclusion perpetua, reclusion temporal, prison mayor, correctional penalty like prison correctional, arresto mayor, distierro, arresto menor, these are the so-called principal penalty. So, pag sinabi natin principal penalty, yun po yung penalty to be imposed to a particular crime. Okay, what about accessory? Accessory penalties are those penalty that is attached to the principal penalty. Now, as you can see here, meron tayo naka-enclose in parenthesis under grave felonies, under the so-called afflictive penalty, meron tayong PTAD. Ano po yan? Perpetual and Temporary Absolute Disqualification or Perpetual and Temporary Special Disqualification. Ano pa, yung mga civil interdictions, those are not principal penalty. Those are called accessory penalty. A penalty attached to the principal penalty. Okay? So death penalty as of now is not imposable, no? Because that was prohibited by Republic Act. Okay? By Republic Act. Okay, 9346, the one signed by President Gloria Macapagal Arroyo, no, which prohibits the imposition of death penalty. So again, if the crime is punished by capital or afflictive penalty, that is grave. So in general, no, the penalties can be grouped into four. No, we have the capital punishment, afflictive penalty, correctional penalty, and light penalty. Okay, now, what about duration? Now, how long is this reclusion perpetua temporal? The duration of penalty will be found under the provision of Article 47. Okay, ano po yun? Yeah, that's Article 47. Reclusion perpetua is 20 years and 1 day to 40 years, while reclusion temporal is 12 years and 1 day to 20 years. Prison mayor is 6 years and 1 day to 12 years. So it means to say, once the imprisonment reaches 6 years and 1 day, that is already for what? For grave felonies. Okay? On the other hand, prison correctional has what duration? 6 months and 1 day to 6 years. Arresto mayor, we have 1 month and 1 day to 6 months. And arresto menor, which is 1 day to 30 days. So yan po yung may mga durations, no, na penalty. Okay? Yung nakalista po dito sa right side, sa middle, under Article 25, yan po yung tinatawag nating degrees of penalty. Death, reclusion perpetua, down to arresto menor. While under Article 27, yun po yung duration ng penalty, which can be divided into minimum, medium, or maximum unless the penalty is called indivisible. Ano po yung indivisible? Ito po yung reclusion perpetua to death, no? And in special law, life imprisonment. Yan po yung mga tinatawag na indivisible. Hindi po sila pwedeng hatiin into minimum, medium, or maximum. With exemption of reclusion perpetua, maybe in case of applying the principle of parole, no, under the indeterminate sentence law. So generally, reclusion temporal pababa, sila po yung divisible, yung pwedeng hatiin sa minimum, medium, and maximum period. Now, question, if death was already been abolished, now what will be the penalty for those crimes that are punished by death? No, the Supreme Court or the law is clear. Under Republic Act 9346, in lieu of death, if the crime is punished under the revised penal code, okay, or using the penalty under the revised penal code, the death penalty shall be reduced to reclusion perpetua. On the other hand, those crimes which carries the penalty of death, okay, but the penalty does not use the nomenclature of penalty under the revised penal code, like in special laws, no, where they uses life imprisonment, okay? So death penalty will be reduced to life imprisonment. And a good example of that is yung Dangerous Drug Act, yung comprehensive as amended, no? Yung ating Republic Act 9165. Under that law, the maximum penalty is death, no? But death is prohibited, so from death penalty, drug cases that covers death penalty will be reduced to life imprisonment. So that is the effect of the implementation or enactment of Republic Act 9346. Now, but aside from this Article 9, 25, 26, and 27, yours truly also incorporate the provision of Article 90 and 92. Ano po yun? Yung prescription of crime at yung tinatawag nating prescription of penalty. Okay, but before that, let me give you a cue how to memorize penalties. Okay? So, titignan po natin, simula arresto minor, nagsimula siya ng 1 day hanggang 30 days. 30 days is automatically 1 month. So, yun naman po ang simula ng arresto mayor. Lalagyan lang po natin ng 1 day hanggang 6 months. Tapos, yung simula naman ng prison correctional, yung 6 months, dadagdagan lang natin ng N1 day. So, as you can see, 1 day to 1 month, tapos 1 month to 6 months, 6 months to 12 years, 12 to 6 years rather, 6 years to 12 years, 12 years to 20 years, then 20 years to 40 years. Ang difference lang, yung simula, lalagyan lang po natin ng end 1 day. Okay? So all you need is memorize 1, 1, 6, 6, 12, 20 to 40. So 1 day sa taas, 1 month, sumunod 6 months, sumunod 6 years, sa taas niya 12 years, sa taas noon 20 years to 40 years. Lalagyan lang po natin ng in 1 day, you can already memorize the duration of all these degrees of penalty. Okay? Now, what is the addition? The addition is Article 90 and 91. Look at this. 92 rather. 90 is the prescription of crime. Ano po ba yung prescription of crime? Yun po yung certain period that a case must be filed in court. And the reckoning period is from the date or time of the discovery of the crime, no? Whoever discovered it, whether the offended party, the family relatives, or the peace officer or public officer. That's the reckoning period of the counting. Okay? Once the crime was discovered, the case must be filed within a certain period. Once that period lapsed and a case was not filed, then that already terminates the rights of the state to prosecute a certain crime. Yun po ang tinatawag nating prescription of crime, which is discussed in Article 90 and also in 91 with regard to the counting. Okay? So, according to Article 90, all those crimes punishable by death or reclusion perpetua, including reclusion temporal, must be filed within 10 years from the discovery. Otherwise, failure to file the case will extinguish the crime. Okay? Yan po. Lumalabas po yan sa board exam. Now, what if the crime is punished by prison mayor? Then that crime must be filed within 15 years. The lapse of 15 years extinguishes the rights of the person to file a case and also remove the power of the states to prosecute the crime. Okay? Now, what about those crimes punishable by prison correctional, no? Which is the 6 months and 1 day to 6 years. The prescription po ay 10 years. While those crimes punished by arresto mayor, the prescription is 5 years. While in some other crimes, meron po tayong ibang prescription. Like for example, in libel, that is 2 months. Another 2 months. 2 years. Slander is 6 months. Yung other light penalty is only 2 months po. Pero yung sa mga special law, meron po tayong specific provision of law with regard to their prescription, no? Like now, may mga amendments tayo. Yung anti-graft and corrupt practices, plunder is now 20 years prescription. So even if the crime was discovered 10 years ago, the case can still be filed, no? Even if the person is no longer working in the government, as long as 20 years does not lapse, the case can still be prosecuted against the public officer. Okay? So yan po ang prescription of crime. So again, the counting starts from the discovery of the crime. Now, kailan po ma-interrupt yung yung period? The moment the case was filed in the court. Okay? The period will stop. And once the case was terminated, the counting will continue. Okay? The moment this prescription already lapsed, then the court or the state cannot anymore prosecute these offenses. Okay? What about Article 92? Okay. 92 is about prescription of penalty. Ano naman po ito? This is applicable for those already sentenced for the crime that they have committed. So, if their sentence is death, reclusion perpetua, yung dalawang po yun, magpe-prescribe po yan ng 20 years. What does it mean? Kapag siya po tumakas o nakatakas sa kulungan, yung prescription po na 20 years ay naglapse, wala na po siyang penalty. Yung penalty po niya na death or reclusion perpetua is already extinguished. Yun po yun. Kaya dapat we discourage prisoner from escaping. Okay? Ito po yung magiging consequence niya. So, ina-apply po natin to kapag may evasion of service of sentences. Okay? What about those crime which penalty is reclusion temporal? So kung penalty niya doon sa crime niya ay reclusion temporal at siya'y tumakas within 15 years, matatapos po yung penalty niya. Hindi na po siya pwedeng parusahan for that penalty. So as you can see, reclusion temporal and prison mayor, pareho po siya sa prescription of penalty. 15 years. Yung prison correctional, 10 years, arresto mayor, 5 years. So halos pareho lang sila ng prescription of crime at prescription of penalty, no? As you can see. So madali siyang i-memorize. Ang pinagkaiba lang yung reclusion temporal. 20 siya sa crime, 15 siya sa penalty as prescription. At yung light felony, doon sila nagkaiba. 2 months pag arresto minor, 1 year kapag sa penalty ang pinag-usapan. So, dapat alam ito, no, ng ating mga especially na sa mga penitentiaries. Pero dapat nga itong Article 92 hindi alam ng mga preso kasi kung alam nila yan, that might motivate them to escape from prison, no? And all they need is to go in a far place so that they will not be arrested, okay? But take note, once the person is outside of the Philippine jurisdiction and the country where they went is not a signatory, no, to the extradition treaty agreement of the different countries in the world, hindi po magka-count yung prescriptions of crime or prescriptions of penalty. So kahit abuti sila ng 20 years to sa ibang bansa, hindi po nagka-count yun kasi hindi po signatory yung bansa na pinuntahan nila sa extradition agreement. Okay? Pagbalik nila dito, pwede pa rin sa kasuhan or pwede pa rin silang arrestuin in the case of prescription of penalty. Now, some might be asking, sir, what about distiero? Okay, that's good. Distiero is not actually imprisonment. It is only a restriction of liberty found under Article 87 of the Book 1. And that was asked in the board many times. Ano po yun? You will be prohibited from entering a place, no, with a radius of not less than 25 kilometers, but not more than 250 kilometers. So you will stay in the community, but you are prohibited to enter a certain place with that certain radius as specified in your penalty. The purpose is to prevent possible retaliation from the victim or from the families of the victim. In case you enter the facility or the place that you are prohibited by law, pwede kang kasuhan pa rin ng evasion of service of sentence. Why? Because distiero is a penalty. The only difference is it is being served in the community, not in the national penitentiary or local penitentiary. Okay? So that's it. Another addition that I made here is this one, Article 39. Ano po ito? Yung subsidiary. No? Alam natin na there are people who doesn't have money and property to pay the fine. Take note sa fine po ito sa multa na apply, no? Kapag yung sentensyado po ay walang money at walang property na pangbayad sa fine, hindi po sa civil liability, sa fine, yung babayaran sa government, pwede pong i-convert yung fine into imprisonment. Yun po yung subsidiary penalty. Pero may good news. Good news, hindi po siya applicable sa grave felony. Ang subsidiary penalty is only applicable to less grave and light felonies. Take note, ha? It is only applicable to less grave and light felony. Under the old law, in the revised, 8 pesos per day. So, kung meron kang 40 pesos na hindi mabayarang fine, ko-convert siya sa divided by 8, 5 days imprisonment yon, no? Pero now, binago na po yan ng mandatory law. Ang basis na po ngayon ng subsidiary is yung maximum na minimum wage applicable in your city or municipality. So, halimbawa, sa municipality nyo, ang pinakamataas na minimum wage ay 400. Yung 400 po na yon ang i-divide doon sa fine and yun naman magiging fraction ng inyong subsidiary penalty na idadagdag doon sa principal penalty. Ganun po yun. Okay? Okay. Now, pero may limitation po ang sabi ng batas. Hindi po pwedeng lumagpas ng 1 year ang subsidiary penalty. So, syempre, unfair naman, ano? Sa mga mahirap, kung i-convert mo, paano kung milyones yun? Di, baka doon sa subsidiary, mas mataas pa doon sa principal penalty. Okay? So, kapag ang penalty mo ay prison correctional, pababa, may subsidiary. Kung wala kang pambayad at wala kang property. Pero kung may property ka naman at pambayad, walang subsidiary penalty na idadagdag sa iyong imprisonment. Okay? So kapag prison correctional o aresto mayor o aresto minor ang iyong kaso at merong kasamang fine, wala kang property or money, magkano na ang subsidiary? Not more than one-third of your term, but not more than 1 year. So, maximum of 1 year. Ngayon, kung ang penalty mo lang fine, walang imprisonment, pero wala kang pera, wala kang property, yan, convertible siya sa subsidiary penalty. Kapag yan ay grave felony at less grave felony, ang maximum na subsidiary mo lang ay 6 months. Ngayon, kung yan ay light felony, ang subsidiary penalty mo lang is maximum of 15 days. So that's how you apply subsidiary penalty. Okay? And, syempre, ayan, the last addition, no? Under the book 2, meron tayong titawag na arbitrary detention. Proper, yun po yung nag-detain tayo ng walang legal grounds. Pero meron tayong titawag na warrantless arrest, no? Kaya lang sa warrantless arrest, kailangan ma-file yung kaso. We have to file the case to the court within a period of what? 36 hours kapag grave felony, 18 hours pag less grave, at 12 hours kapag light felonies. Lumalabas din yan sa board exam. So, you have to take note of that. 12 hours, 18 hours, and 36. No? Exemption, yung ibang special law, like yung Human Security Act, that is, pinakamabigat yan ngayon. Na anti-terrorism law is 72 hours or 3 days ang kanyang maximum detention under warrantless arrest. So, make sure you are able to memorize the degree of penalty and you also know the duration and this one because they are also asked in the board exam. Madali naman pong tandaan, no? Yung Article 125, yung under ng warrantless arrest. Kasi yung una, light felony, isang dosena, 12. Tapos yung less grave, dibu ng babae, 18. Tapos 18 times 2, 36 yung sa grave felony. So you were able to memorize practically 9 or 10 articles now in just short presentation. Okay? So thank you so much. I hope this is very helpful to you in the board examination. So again, it's a great day. Count your blessings. Health is wealth. Mental health is very important. Take care of it. Thank you and God bless you. Once more, this is Dr. Ariel Manlusok, ADMRC Director. Thank you and God bless. Keep safe.